So lawyers love this common law because they can BS their way through it. I've attached a letter to this video requesting validation under my old FDCPA very burdensome proofs requirement. The UCC also has a validation aspect, and my letter will invoke the FDCPA rights. I'll attach it to this video. I don't know why a car dealership would tell you we got problems with this car. We really don't have a title. But if you don't have knowledge, you may get a free car. I'm not saying go do that. 3 ways that you can use the UCC. 1. All right, hey, Brian Parker here with another interesting video. This may not be interesting, but a lot of times commenters say to me, hey, in fact, on my YouTube channel, I'm answering that all the time. And then members and commenters, members of Killdebt.com will go, hey, can you do a video on blah, blah, blah. So a commenter said this, Shazam, can you do a video about how car dealerships have liens on vehicles before you can even make a purchase of it? The commenter was looking for information on the UCC, so I wrote, doing a UCC video soon that might help, but that's a small topic. I will try to include a mention. Car dealers are paying interest on vehicles they borrow in a sense, and someone else has a pre-sale lien. Let me do more work on it. So I did, and it became a ton of work. I just spent all Sunday morning writing this, or at least researching it and coming up with it. So I'm gonna give you, I'm gonna give you a background on UCC, and it does have an application on a debt defense that I rarely go with unless you may have seen my videos on deficiency judgments or handling a repo. Let's put them up there. There's 3 of them. There's also videos on post deficiency, meaning they took your car, they repoed your car, now there's a debt owed from the difference between what they sold it for, what the actual loan value was. That has a UCC aspect to it. So I'm going to show you what the UCC is and what the UCC isn't. You're going to be surprised, maybe. So you always hear people go, what about the UCC? In my 30 years, UCC this, UCC this. I weirdly, as much work as I've done on the UC as my brain's going right now, in the first maybe 10 years of my practice, I did a tremendous amount of what's called lemon law. And under the federal lemon law, under the Magnuson-Moss Warranty Act, that had a big UCC aspect to it. And revocation. So if someone sells you a bad car and they didn't tell you something about it that could cause you great harm, then you're entitled to revocation, and that is a UCC aspect to it. So I'm going to tell you something I never knew before. I don't know why I would, but we all go UCC this, UCC that, but there is no such thing as the UCC, believe it or not. So I'm going to clarify that. The UCC was created, that doesn't exist, by the Uniform Law Commission and American Law Institute, so the ULC and the ALI. They are private organizations that have no legal authority, okay? So the Uniform Law Commission, Shazam, was created in 1892, and it's still telling us how we should run our lives. Hey, just like the Constitution. Commissioners, usually appointed by state governors, are on their board. And you think of them, or you must think of them, as a legal suggestion box or recipe writers. So the American Law Institute is the baby of the 2 groups. That's 1923. It's made of lawyers, judges, and law professors and academic people, all right? So you can go find the UCC from the Uniform Law Commission or the ALI. That's a group of model suggestions, let's put it that way, that the state legislature will, hey, that's a good idea, we're going to make that in law. Then they'll have their legal debate, etc. You can find that on state legislature websites, meaning you can find the UCC on any state legislature. Obviously books, just Google your state UCC or your state commercial code. So every state offers a UCC or Uniform Commercial Code, but it does not exist. I'll keep going on that. Every state except Louisiana, which has its own version. In fact, of the many articles that are available, Article 2, they don't even recognize. They have their own thing going on. So when a ULC and ALI creates this idea of a law that should be adopted or a code, it's called a model code. It's not the actual law, it's called a model code. It's a model. So it's like when you invent something. You have a prototype, but the actual end product that you sell to somebody is different. So they sell their prototype to legislatures, not sell. And then the legislature said, hey, we need that with the state aspect to it. So a good example of an Article 9 UCC code is Section 9609, Shazam. So that's from Article 9. And in California, that would be called California Commercial Code 9609. In New York, NY UCC 9609. In Texas, and I just finished a case in Texas using their UCC, and it was in federal court, Western District of Texas. My first Texas federal case, and that largely was based upon the state version called the Texas Business and Commission Code, Commercial Code 9609, if you will, if you were using 9609. So for your purposes, your debt defense purposes, and I will get to my commenter's question, your state is your version of the UCC. So the ULC and the ALI say, hey, here's a good idea. And they say, check out the UCC. It's the UCC that we think we're referring to. We're not referring to that. We're referring to your state's adoption of their version of what's a recipe or a good idea. They're adding their salt, adding their sugar to it, but there is no UCC, all right? So it's just a bunch of model or uniform versions with zero legal effect until a state picks what they like and makes it a law. So to reiterate, in California, it's the California Commercial Code. In New York, the New York Commercial Code. In Texas, the Texas Business and Commercial Code. But in good old Louisiana, they have their own version of the whole thing called the Louisiana Revised Statutes, and it is based on civil law. Everybody else's law is based on common law. They are based upon civil law. What's that mean? Common law versus civil law. Common law is based on precedent and judicial decisions. A good example with no apolitical reason, Roe versus Wade. The abortion's allowed in all the states. That's the precedent. The new Supreme Court said, no more, Charlie. The state decides, just like the UCC. So that no longer exists as precedent. So common law is based upon judicial precedents. The judges play an active role. You hear all the time about people complaining about activist judges. That's what they're talking about. They're creating common law that doesn't exist in the original law. So lawyers love this common law because they can BS their way through it stuff. And it's more flexible and adaptive. Civil law that Louisiana goes through is based on comprehensive codes. Judges primarily just interpret. Less emphasis on precedent or presidential case law. So that means less BSing. And then lawyers argue from the text only, not a case interpretation, less BSing. So it's more predictable, but less BSing, or flexible. So for the purposes of your use, the UCC primarily governs commercial transactions between, in your case, debt buyers. Okay, so here's a bill of sale. Here's my couple of bill of sale videos, Shazam, and some assignment videos. UCC would cover that aspect, that commercial aspect. So it covers sales of goods, secure transactions. I hated secure transactions in law school. I think I got a C, see me or free me, and negotiable instruments. So Article 3 and Article 9 are the ones that you should be concerned about if you are from a debt collection aspect or context. So 3 covers, as I said, negotiable instruments like promissory notes. So you have a loan agreement with FinTech, that is covered by Article 3. Article 9 covers secure transactions secured by a lien or a security interest, which is relevant to many of your consumer debts. So When I say cover, that means when Article 3 covers promissory notes, it means Article 3 defines what legally qualifies as a promissory note. Is this a real loan agreement pursuant to the UCC? If you look in your loan agreement, they'll have UCC reference all over the place. It establishes how rules work. So if a loan agreement is in violation of those rules, you can use that to say, there's no agreement, they breached the contract, yada. Determines rights and obligations of the parties and remedies that you can use to win under Article 3. So it's like a rule book, really. So if, for example, you want to play soccer, you got to follow the rules. The rule book says, hey, this is a goal. It's got to be made up of 11 players. This is a foul. This is offside. Just, that's what it is. The UCC is a rule book for whatever endeavor you're involved in. Briefly, Article 9, secure transactions. That's what constitutes a security interest in personal property, liens, stuff on cars that the gentleman was asking about. There's certain filing requirements. I'll just say this, a lot of people come to me to get them out of business debts, and a lot of those are called receivables loans. So they'll get a bunch of money, and then the person that lends the money to the business debtor, that person has the right to collect parts of their receivables for return payments. That's a business context. So they've got to, if you will, file a security interest or a lien on the receivables. Article 9 sets priority rules. So if there's a bankruptcy and there's all these creditors standing in line, it would be who's secured, who's unsecured. An unsecured agreement or loan is a credit card. That's unsecured. That's good luck collecting on that if you're going through bankruptcy. Homes, they have nice collateral. So it's all about collateral. So we look at the Uniform Commercial Code. These are the relevant things to look at. We look at Article 1, that's the general provisions. Article 2 is sales. Remember I said Louisiana doesn't like that. 3 is what you should be concerned about, negotiable instruments, checks and notes, agreements. 4, bank deposits, and then 9, secured transactions. So the bottom line is, if you are researching the UCC, don't go federal. It doesn't exist per se. Your state legislature is the force of law. So whatever state you're in, it's the state's version or the actual law that is gonna apply to your state defense case, all right? So for our defense needs, again, Article 3 and Article 9 is what you should look at. So for example, our friend that was asking about the car and the car loans, this is how the UCC works on car loans. So Shazam, creating the security interest. We talked about it's collateralized. For a dealership to have valid lien on your car, they must give you value, you must have rights in the car, and there must be a security agreement that is signed by everybody. If they can't produce a signed, hear this out, signed security agreement, their lien may be invalid, and that's a place where you can go, especially if you're 2 steps into a deficiency judgment case. And that's important too. I've done a lot of, and these are fun cases, they're called repo cases or yo-yo. A yo-yo case is a person of limited means will be sold a car with a loan, and let's say it's 9%, they drive away, they get a call, hey, something went wrong with your financing, you gotta come back in and sign new papers and it'll be 11%. It's called yo-yo. You keep sending them out, bringing them back. And for attorneys and for people that are subject to that behavior by bad car dealerships, that's a lot of money. It's all triple damages, triple attorney fees, triple damage. It can get really bad. So as far as quickly, I'll give you a quick tip. When you buy a car, even today, even though everything's online and by email, you will have paperwork that goes in your glove compartment. And for 30 years, I've told people, take the paperwork out of you. Don't leave the original agreement in the glove compartment, because when you say, no, I signed, and by the way, you're right, I signed for 9%, you can't make me come in and sign. They'll repo the car and take with them your paperwork in the glove compartment. Good luck proving everything. So when you buy a car, as a matter of course, take the paperwork out of the car so you always have proof. That's just a little tip for you. You can do what you like. Common defense issues with car dealerships, and that's again a debt defense aspect if you're being sued for the deficiency judgment. A dealer sold you a car that didn't have a clean title. Under your state's version of 9-317, you might take free of prior security interest if you bought without knowledge. I don't know why a car dealership would tell you we got problems with this car, we really don't have a title. But if you don't have knowledge, you may get a free car. I'm not saying go do that. A lender cannot repossess without a 9-37 your state's version of the UCC. If there's spot delivery or those yo-yo deliveries I was talking about, and the dealer lets you drives off with the car knowing they're going to be pulling you back again, you have a security interest defense if you hold on to that 9% as opposed to the 11% they're using to say, hey, she stole the car, we just let her take it for a test drive. And believe me, I did a lot of dealership litigation. I don't know how else to put this. The most lies I ever saw, it wasn't the manufacturer, it was the car dealership. And I went to a seminar once. I said, why do they lie so much? They said, because there's so much money. Follow the money. He said, if you ever have a problem, follow the money. So follow the security interest and hold on to it. So I've done videos on repos. Let's put up a repo video. And that's all about a couple of things. They're not allowed to, let's say you've got the car in the garage and the repo guy comes banging on your garage and says, you got to open this up, you don't have to do that. And he can't breach the piece. And this happens. They'll take a crowbar and try and open the garage door, or they'll get rough, or they'll show their gun. You can't breach the piece. Even if someone hasn't made a payment on something, you can't break the law to fix or repo a car or fix a debt. So breach of peace is a defense. Again, the repo stuff I've done, if they take the car, they've got to give you proper notice under your state rules. I've had cases where they didn't give notice, and they've got to sell it in a a commercially reasonable way. Meaning, let's say it's worth $10 and they sold it for $4. Now they're suing you for 6 plus interest plus charge. That's not sold in a commercially reasonable way. So if your car, I've got videos on this, but if your car gets taken, I've got letters attached to those videos that you immediately send out to everybody saying, I need proof of the sale, how much you sold it for, how much did you, because they advertise it. How much did you advertise the car versus was there a legitimate sale, or were people just doing it in the back room? So there's all sorts of ways you can beat them using my letters that I attach to those car repo videos. I'll have a letter attached here, a really good one. So Article 9 governs the sale and assignment between creditors, but an important thing that you should know, while you know I've spoken highly in just about every freaking video about, is there an assignment between these two entities? If there isn't, you've got a challenge, you've got a defense. You can say they don't have standing, but you don't in commercial cases. You can't go, hey, debt buyer didn't do this and didn't properly sell the thing. I'm looking at the agreement and I say that agreement, the bill of sale, the assignment is false. If you are not part of that, meaning it was between party A and party B, you have no right to complain. Even though the fact that your debt obviously wasn't in that assignment, you can't complain about that with exceptions. So what do I mean by that? Under a commercial aspect, you can't complain about party A and party B's right to claim that they sold something, right? So if they sue you, if party C, the LVNV funding, now you can say prove you have a proper assignment, but you can't go after the parties. So if you're sued, let me put up an example regarding a requirement of a complete chain of title. So there's SoFi Bank, SoFi Personal Loan Trust, Resurgent Capital, and LVNV funding. If the proof of assignment is missing from SoFi Personal Loan Trust 2023, by the way, that's the case I just tried and we won, in the chain of title, on this aspect, in the chain of title, the rest of the companies can't say they have standing. So under UCC, you don't have a right to complain about party debt buyer A and debt buyer B selling something and saying, I'd say that's a bad bill of sale, but you do have a right to yell at LV&V funding for the same reason. They've got to prove it. So you kind of shift the burden, which is nice too. So the rule, at least in Michigan and the Sixth Circuit of Michigan, the federal part of it, is under a case, Shazam, Livonia Properties Holdings LLC v. 12840-12976 Farmington Road Holdings LLC. That's a federal case that says the third party has no assignment rights to two parties selling. In this case, it was a mortgage. The defendant claimed that the assignment of the mortgage to a secured trust, you've heard me talk about securitization, the securitization under debts came from the mortgage-backed security problems of 2008. 2008 was caused by mortgage-backed securities. So in that case, the secured trust, the defense of the third-party debtor, their claim that an assignment of the mortgage to a secured trust was invalid because it failed to comply with the terms of a pooling and service agreement. If you know anything on my securitization, either letters or videos or anything to do with securitization, a trust's lifeblood, like the oil in a car, is a pooling and service agreement. Nothing gets done without that. And so a lot of times in mortgage-backed security cases, I've done them, you go, I want to see the pooling and service agreement, what are the rights of the parties, blah, blah, blah. Well, this third party claimed the mortgage was not assigned inside. There's an originator, a depositor, a bunch of entities, and they all claim ownership at one point inside the trust. So the third party is saying, hey, I don't see an assignment between the originator and the depositor. The court found that a third party beneficiary of the PCA, the debtor, the person that was arguing about the foreclosure, they're not a third party beneficiary of the PSA, the pooling and service agreement. And ironically, while he would appear to have legal standing in some aspects of this, he doesn't have legal standing because the PCA was between the originator and the depositor, and the person who was losing their house because of it had no right to complain. But, and the court said, and this is the UCC aspect of Article 9, if you're not part of the secure transaction, sale of Party A to Party B, or the one I just mentioned, SoFi Bank to SoFi Personal Loan Trust 2023-1, you have no reason to bitch about it. You can't do anything about it. But the Sixth Circuit also said you may assert a defense in a collection case based upon an assignment, any matter which renders the assignment invalid and ineffective. There are 11 defenses, including non-assignability of the instrument, assignee's lack of title, and a prior revocation of the assignment. I see all the time debt buyers sending me briefs and motions and summary dispositions and trial briefs saying, you don't have a right to argue. This is between Party A and Party B. But the federal court, which overrules state, by the way, and so think about that. Every UCC is based upon state rule. You have a federal case, that trumps that. So the Sixth Circuit has permitted borrowers and debtors to challenge assignments of their loans under those three protections. And the theory is, if you can show, listen, if you can show that there's a possibility that more than one person is going to be coming after you for the check, and that, in this case, LV&V Funding, who doesn't have an assignment, has now opened it up to show that all these entities could be coming. And I've done that case. I've had judges quote it word for word in my favor. That's how you beat a defense saying, hey, you have no right to complain about an assignment. You're not Party A and Party B. You go, yeah, but I'm going to be facing double dipping, double coverage, double payment requests because there's no valid chain of title. So I always argue that I'm not complaining about the assignment. I argue there are missing assignments. The chain of title is unperfected and the plaintiff has no standing because of a missing assignment or sale, rather than complaining about one that exists. Don't complain about the one that exists if you want to win the case in a debt defense aspect. So here are three ways that you can use the UCC. One, challenge the proof of ownership in court. So when you are sued, those UCC rights you don't have, you kind of do now. The statute of limitation, the UCC establishes specific time limits under 2.725, your state's version, of sometimes a 4-year statute of limitations for a breach of contract. And now I've attached a letter to this video requesting validation under my old FDCPA very burdensome proofs requirement. The UCC also has a validation aspect, and my letter will invoke the FDCPA rights. I'll attach it to this video. It requests UCC documentation to challenge standing, as I just told you, and creates even more of a burden on debt buyers. So that matters because the UCC argues, as a FDCPA debt validation letter does, you got to prove chain of assignment, you got to prove proper endorsements under Article 3, chain of assignments under Article 9, and perfected security interest if it's a car dealership, and that's Article 9. That's more ammo that forces them to prove they actually own the debt. And remember always, as my letter will say for you, always ask, do you have the right person? So they've got to provide a complete chain of title, account level proof of purchases. That means they got to show the copies of the original paperwork with your signature. Remember, it's got to be signed to be true under the UCC. Original contracts, proper assignments. Without these, they lack state standing under your state's UCC provisions. So for that comment, I know I bored you and I went too long, but you always need a background and then just use the information I gave you. Give that letter a chance when you're sending out a validation letter. But most importantly, go to Killdebt.com for Parker GPT, the super AI power that does everything for you. Coming, Killdebt.com 2.0. Don't forget about that great briefcase. We've got archives, we've got video savings. You'll have your own little briefcase with all this great stuff. It's coming in 2 weeks. Fingers crossed, all right? The 2.0, get in now. So I hope this helps your UCC understanding. Vegas, bye now.